The Supreme Court has just been asked to step into a massive constitutional battle that can completely alter the future of privacy rights in America. This case involves a growing concern surrounding the Fourth Amendment and DNA and genealogy websites and how they can actually be used by some law enforcement agencies going forward. Imagine a world where law enforcement can issue a broad arrest warrant that technically names every single human being on the planet, waits decades, and then uses these websites and their data to build a profile on you, all without ever even getting a specific search warrant from a judge. This issue is currently at play in the Supreme Court. A case is seeking review, and the case is called Williams versus Pennsylvania. At the center of this petition is a question involving generic no-name warrants and a complete expansion of how the government can use these types of databases and this type of generic John Doe warrant. So today we're going to break down the legal mechanics behind this case, the concept of genetic profiling, and why this petition could draw a very definitive line in the sand when it comes to the Fourth Amendment going forward. So let's break down what is happening. Now, before we jump into this case that is pending in front of the Supreme Court, if you like this type of content and you want to ensure that you get it going forward, click on the notification bell, turn on all notifications to ensure you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, for a limited time, if you use my link down below and you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee, but that is only until the end of this month. Now, when it comes to this case, let's start with the first major constitutional issue that is raised in this petition for Supreme Court review, and that is the concept of a John Doe warrant, essentially that fails to identify a specific person. The Fourth Amendment is pretty clear when it comes to this topic. It states that no warrants shall issue but upon probable cause, and it specifically demands particularity. That means that it must describe the exact person or things to be seized. Now, back in 2000, a case was actually put on pause, and while this pause, legal timeline was happening, investigators in Pennsylvania filed an anonymous complaint against a John Doe. Now, the problem with this, and really what caused this case, is that the warrant did not attach any actual specific profile or unique identifiers when it came to the DNA. Instead, it merely listed 6 generic locations or markers on human chromosomes, aka that DNA. This was one of the first times in the country where this type of generic John Doe warrant was actually issued. This all was in relation to an assault that occurred back in 1995 at a college, Penn State, at State College, Pennsylvania, actually my alma mater. So this was a case that essentially happened back in 1995. There was this generic John Doe warrant attached to this DNA, and then it sat there for decades. The assault went unsolved, and all the law enforcement really had to go off of for this entire period was DNA that was collected at the crime. But here's the catch from a legal and scientific standpoint. Those 6 specific chromosomal locations that were used by law enforcement to get the John Doe warrant are found in every single human being on the earth. They are universal. The Supreme Court petition argues that listing these generic locations without an actual unique identifier attached means that the warrant described absolutely nobody, but also everybody all at once. Now, on review, the lower state courts kind of brushed this off, calling the objections to this, just too hyper-technical, but many pointed out that requiring the government to actually name or uniquely identify a suspect before getting a warrant isn't a technicality. It is the literal core of our constitutional protections against broad general government searches. But this case gets even more legally complex when you look at how investigators eventually zeroed in on the suspect decades later and how this individual was eventually caught. After utilizing private genealogy databases to map out a potential family tree, investigators began conducting surveillance on this individual. Law enforcement zeroed in on the suspect here based on the fact that his mother had actually submitted her DNA to one of these genealogy databases, and based on that, it was flagged, based on the DNA that they had collected by the crime. So in 2021, they collected some discarded items from trash cans outside of his home, including some discarded containers. Law enforcement also followed them and went to a public event and gathered some utensils that were used by his child, and they extracted some of that DNA also from that sample from the child. The lower courts upheld all of this by relying on what is known as the abandonment doctrine. This is the legal rule that says that if you throw something into the trash or leave it in public, you have no expectation of privacy in that item. But the petition here by this individual asked the Supreme Court to reconsider this issue. They argue that while you might actually abandon a physical piece of trash or a plastic fork, you don't actually truly ever abandon the invisible, deeply private information that is floating inside of your body in this genetic material that may be attached to this item. They argue that humans shed skin cells, hair, and biological material completely involuntary every single minute of every day. You physically cannot choose to stop leaving a biological trail behind you. They argue that if the government is allowed to take this position that involuntarily shedding material is fully abandoned, well, then it means that the state has unbridled discretion to map out, sequence, and log the profile of any person at any moment without a warrant. In the petition, they argued that a warrant must be required to extract and map out a genetic profile, even if the physical object is, disregarded, if it's thrown away. Even if that item has been thrown away, you need a separate warrant to actually map the DNA that's on it. They actually point to the landmark case Riley versus California out of the Supreme Court for this proposition that they're putting forward. In that case, the Supreme Court ruled that even if the police lawfully seize a physical cell phone during an arrest, they cannot search the digital data inside that phone without a separate warrant. And the question is why? Well, that's because the digital data contains a massive, intimate swath of a person's private life. And the petition here argues that your genetic blueprint contains infinitely more private, sensitive information than a cell phone. That DNA tracks your ancestry, your biological relationships, your health traits, and also your predispositions and medical history. They argue that if the police need a warrant to look at your text messages on a phone that they've already actually seized or got through a search, then they should absolutely need a warrant to map out your internal code on a piece of item that they recover. This petition is a critical wake-up call regarding how rapidly technology is outpacing our legal frameworks. If the Supreme Court declines to take this case, it gives a potential green light to lower courts to continue validating these anonymous, broad warrants based on genetic markers common to the entire human race. The Supreme Court has never explicitly ruled on the limits of warrantless generic profiling for ordinary citizens who aren't under an arrest, making this an incredibly high-stakes issue of first impression for the Supreme Court. Now, on the other side of this constitutional debate, proponents of these investigative techniques argue that genetic, charting is one of the most powerful advancements in modern public safety. They argue from a law enforcement perspective, utilizing these universal familial markers and disregarded materials allows investigators to kind of breathe life into these cold cases that maybe would never be solved or really haven't been solved for decades. Proponents of this technique argue that it is not about data overreach, it's about utilizing advanced science to solve the unsolvable cases, resolve historical ambiguities, and ensure that individuals responsible for serious public harm or these types of crimes are actually brought to justice. So that is the opposing position when it comes to using these types of broad warrants and using this DNA and these genealogy websites. So I want to hear your thoughts down below in the comment section. Do you think that the traditional rules of abandoned property should apply to our biological data? Or does, the Fourth Amendment need to evolve to protect us from this kind of tracking? What do you think about these broad DNA warrants and the use of these genealogy websites to identify people and use that information that's out there to then, try to solve some of these issues? Let me know your thoughts down below. Where do you fall on this issue? If you like this type of content and you would like to get it going forward, make sure you like, comment, subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.